All right. Good afternoon, everyone. Welcome to the final round of the 2025 UCI Law Moot Court Competition. My name is Matthew Scamahorn, and I've been honored and proud to serve as chair of this year's competition. And on behalf of the Moot Court Board, thank you for joining us. The Moot Court Competition is one of the most rewarding educational experiences available to students here at UCI Law. The mission of the Moot Court Board is to promote the development and refinement of students' legal research, writing, and appellate oral advocacy skills. And each year the board organizes an intramural moot court competition that, of course, has the ultimate goal of preparing students for their legal careers. But we also aim to make the competition fun, with issues relevant to our real-world experiences. And this year's competition involves a fictional case that at its core concerns one of the most fundamental and complicated relationships throughout history, the relationship between a parent and child. This case contemplates the role of the Constitution in protecting it. We hope that this case would give competitors an opportunity to make arguments informed by their own unique human experiences. And today we have the honor of seeing the culmination of our competitors' months of hard work. We're thankful for the faculty, administrators, practitioners, judges, and members of legal communities across California that helped make this competition happen. And I sincerely hope you all enjoy today's event. Now, please join me in welcoming the Dean of UCI Law, Dean Austin Parrish.
Thank you. I don't think Matthew could have said it better. One of the things that we pride ourselves in the law school is graduating students who are able to practice at the very highest levels of the profession. That's part of our clinical program and our pro bono program, but it's also the tremendous things that occur in the advocacy program. So we'll get to it in a second, but congratulations to the board. It's just you guys have done a fabulous job this year. You know, we've got a number of students that are admitted students to the law school. If you've been admitted to the law school and you're here for Admitted Students Weekend, can you raise your hand? Can we have a round of applause for the next generation of lawyers? And if you're a co-decision maker, a family member, can you raise your hand? Congratulations. Let's have a round of applause for them too. You know, well, we're here to witness two outstanding students in their final competition. And I have to say that they seem to have been shaking their heads when you were mentioning that this was fun, at least on the final rounds here. But this year's moot court competition has been ongoing for many months. It started with 62 competitors and 31 brief writing teams. 46 attorneys and state and federal judges judged 68 oral arguments. 20 faculty graded the competitors' Supreme Court briefs, each brief graded 3 times, and 23 first-year law students served as bailiffs. So as we begin tonight's program, I'd like to thank the members of the 224-225 Moot Court Board for the tremendous work they did this year. That's Chair Matthew Scamahorn. Let's have a round of applause for Matthew. Oh, I messed up. I now got to do applauses for everybody individually. But so we have vice chairs, Katie McKee and Jade Naramatsu, for the vice chairs. Our directors of the bench brief, J.B. Elberford and Sunny Liu. The chairs of judicial relations, Devin Ton and Karen Trin. Congratulations. And then our chair of internal relations, Matthew Finn, and Kasra Mirza Begafini. Did I get it close? Yeah, I did. I'd also like to thank our sponsors, the Buckhalter Law Firm, who have once again generously supported this year's competition. And I'd especially like to acknowledge Josh Robbins for his advocacy in securing the firm's sponsorship. Can we have a round of applause for Josh and Buckhalter? And finally, I want to make sure that I thank all the judges and volunteers who made this year's competition a success. Now, as we move on to the competition, we're going to hear from the two tremendous finalists, Danny Jaffe, who's the petitioner, and Amit Chana, who's the respondent. Let's have a round of applause before they even get started. I've been asked to read a short summary of the case. Timothy Gray is the biological father of Anthony Huntington. In 2023, Anthony, then 23 years old, reached out to Timothy to arrange a meeting. Anthony initiated that meeting because his fiancée was pregnant, and Anthony wanted Timothy to be included in his grandchild's life. The meeting was the first time that the two had met in Anthony's life. Timothy separated from Anthony's mother when she was pregnant with him. That meeting went well. Timothy expressed his intent to develop a relationship with Anthony and his future grandchild. Unfortunately, Anthony died a few days later in an altercation with the Baltimore police after he was mistaken for a dangerous suspect. Timothy sued the Baltimore Police Department under 42 United States Code Section 1983, arguing that he has a substantive due process right under the 14th Amendment's Due Process Clause to companionship with his adult son. The police department moved to dismiss under Federal Rule of Civil Procedure 12b-6 for failure to state a claim. The district court denied the motion and held that Timothy's right exists. The Fourth Circuit reversed, holding that Timothy has no such right. Timothy has now appealed to the Supreme Court of the United States. The question presented before the court is whether the petitioner, Mr. Timothy Garay, has a substantive right under the 14th Amendment's Due Process Clause to companionship with his 23-year-old son. Judging tonight's competition will be three of our country's top jurists. Before they join us, let me tell you a little about each of them. The first is the Honorable John B. Owens, who serves on the United States Court of Appeals for the Ninth Circuit. Judge Owens has served on the Ninth Circuit since his nomination in 2014. He is seated in San Diego. Before joining the Ninth Circuit, Judge Owens was a litigation partner at Munger, Tolles & Olson. A graduate of Stanford Law School, he served as a law clerk to Justice Ruth Bader Ginsburg of the United States Supreme Court and for Judge Clifford Wallace of the United States Court of Appeals for the Ninth Circuit. Our second judge is the Honorable Anthony D. Johnstone, also of the United States Court of Appeals for the Ninth Circuit. He has served on that court since his nomination in 2022. He is seated in Missoula, Montana. Prior to joining the United States Ninth Circuit Court of Appeals, he served as Solicitor General for the state of Montana from 2008 through 2011. For more than a decade, Judge Johnstone has also taught at the University of Montana's Alexander Blewett School of Law, where he was the Helen and David Mason Professor of Law. A graduate of the University of Chicago Law School, he clerked for Judge Sidney Thomas of the Ninth Circuit. Lastly, we have the Honorable Josephine L. Stanton, who is the United States District Court Judge for the Central District of California here in Los Angeles. She was confirmed to the Federal District Judge for the United States District Court in 2010. She previously served as a judge of the Orange County Superior Court, and prior to that, she was a partner at Morrison and Forrester. A graduate of Harvard Law School, she served as a clerk for Judge John R. Gibson on the Eighth Circuit Court of Appeals. She also sits as a member of the UC Irvine School of Law's Board of Visitors. They'll soon arrive, but can we have a round of applause for the service of all three judges? With that, my duties are over. It's going to be a fabulous evening, and we'll turn it over to the bailiff. Thank you.
All rise.
You may be seated.
Hear ye, hear ye. The court is now in session. The Honorable John Owens presiding alongside the Honorable Anthony Johnston and the Honorable Josephine Stanton.
Good afternoon, everyone, and welcome to the special setting of the United States Supreme Court. Just real quick for the Admitted Students Day, if you could raise your hand if you're a potential student here. Wow, okay. So it may seem impossible to believe, but in 3 years, this could be you. All right, so just law school goes very fast. So I know this may seem very intimidating, but in 2 years from now, this is going to be a piece of cake for you. And with that, Counsel for petitioner, if you could go ahead and step up and make your appearance.
Your Honor.
And the case today is Gray versus Baltimore Police Department.
Good afternoon, Your Honors. May it please the court. My name is Daniel Jaffe, and I represent Timothy Gray, petitioner Timothy Gray. May I please reserve 5 minutes for rebuttal?
You may just keep track of your time.
Thank you. The love a parent has for their child, the suffering a parent experiences when they lose their child, does not evaporate when the child turns 18. There is an existing right to companionship under the Constitution for minor children. The exclusion from this right of adult children is arbitrary and contrary to this court's precedent for 2 reasons. First, companionship between a parent and a child is deeply rooted in this nation's history and tradition. Substantive due process protects this right to companionship regardless of the child's age and regardless of whether the parent was a model parent. Second, the First Amendment right to intimate association supports the right to companionship because the relationship between a parent and a child is among the most intimate associations and relationships in all of human relationships. For those 2 reasons, the rule that this court should adopt is there is a right to companionship between a parent and their child, period. This easy-to-apply, workable rule is comprehensive, and it will best comport with our nation's history and tradition and protect the rights and relationships and love that a parent has to their child. The first argument that there's a right to companionship between a parent and a child because it is a fundamental liberty deeply rooted in our nation's history and tradition has 4 supporting arguments. First, this court's substantive due process jurisprudence defines fundamental rights comprehensively and rejects arbitrary exclusions from these rights.
So, counsel, let me jump in with a question here. I'm trying to understand the limits of this right. So, for example, I understand you're saying the parent should have a right towards the child, but let's say I turn 18 years old, and I say, I don't want anything to do with my parents anymore. They were bad parents. I want to move on with my life. Under your reading of the 14th Amendment here, can a child say that? Or are they somehow now attached to the parent because the parent has some right of association with the child?
That would get more to circumstances under which the right may be waived or forfeited or certain exceptions to the right. But that doesn't get to the baseline question of whether a right exists at all. So under this court's jurisprudence, among other reasons, biological interest of natural parents creates a cognizable and substantial interest to the right of companionship. So
let me ask you, when you say the right of companionship, our prior cases tell us that we need to define the fundamental liberty right very carefully. What is your definition of the right to companionship? Is it that broad? Just how do we interpret that?
The right to companionship would include the ability to have associations with your child. Certainly in this case, the right to see the birth of your grandchild, to have important family events together. It's an associational and relationship right.
All of those, is that an inclusive list, or those are just examples?
Those would be examples. Ultimately, there is an existing right to companionship, which in essence, it is just the right to be there with your child and to have a relationship with your child, free of government interference and government actions that take your child away from you.
But isn't the right, hasn't it, at least in the past, been defined really as the right to guide your child into adulthood, the right to control education, those sorts of things? Has there been anything as broad as what you're saying that's ever been it's supported by the case law?
There's two responses to that question, Your Honor. The first is that this court said in Obergefell that rights should be defined comprehensively. And this court has already ruled in cases like Stanley v. Illinois that there is a right to companionship between a parent and their child. And that right has existed independently of the right to care, custody, and control, and to guide your child.
Counsel, does that broad framing that Obergefell announced survive Dobbs?
Yes. It
Why?
Because under Obergefell, rights do not merely exist as they always have in the past. Obergefell explicitly says that if we only look to prior historical practices and to people who and how rights were defined in the past, then new groups that were excluded would never be able to have rights that were once denied to them.
But adult children are not a new group. They've been around since humanity has existed. So how does that work, right? The tradition, I think, is tradition. The tradition has drawn the line at childhood and minor status, perhaps because the tradition is that children lack legal capacity. And so if a parent does not have the right to certain custody or control and upbringing of a child, the child themselves doesn't have that capacity. That's not true for adult children.
Yes. Two responses to that, Your Honor. The first is that the right to companionship, the current age line is arbitrarily driven, which is contrary to this court's precedent. This court said in Moore that we don't look to the outer bounds of due process based on arbitrary lines. We look at respect for history and tradition. So when you're looking at factors like reliance on family members, oftentimes this exists well after the age of majority, whether it's care, children stay on their parents' health care plans, well after age of 18, whether it's relational aspects and association aspects. The relationship between a parent and their child is similarly an intimate and important and special relationship well after age 18. The second response to that question is that in the context of Obergefell, and that there's always been children, adult children. Similarly, there was also always LGBTQ people. There have always been interracial couples. That did not stop this court when defining fundamental rights in cases like Obergefell and in cases like Loving v. Virginia from nevertheless saying that this is a constitutional right. The key framing issue here is not whether an adult child and their parent have this right to companionship. It is that there is a right to companionship between a parent and their child. So is there sufficient justification for excluding the relevant class of people from the right? And for the reasons that I just mentioned, the exclusion of adult children is arbitrary because long after age 18, there remains special associational aspects of the parent-child relationship, and there is still a significant degree of reliance, whether it is financial or in terms of health care and other aspects, such that it doesn't just evaporate when the child turns 18.
But it changes substantially, doesn't it? I mean, again, going back to...
You hope so.
Yes, for those of us who have 19-year-olds. But the tradition, when it comes to this right, has been the parent shaping the development of the child. And that is different. That is different in kind than just having an associational interest or helping out. If that's the standard, why wouldn't we say, hey, your rich aunt is also, that you have a relationship with her, and that there's a fundamental liberty interest in your relationship with your cousins or your siblings.
Or a teacher. I think, I was closer to probably my fifth grade math teacher than I was to my dad. So, like, would Mr. Walsh be able, under your theory, would Mr. Walsh have a stronger claim than my father? Because growing up, I spent more time at school than I did with my dad, like something like that. How would we evaluate that?
Sure. Two responses to those questions, Your Honors. The first is that the guiding and development aspects that a parent gives to their child does not just cease at age 18. The relationship changes, but it also changes from when a child is an infant or a teenager going off to college. Children and young adults develop throughout the course of their life, and this goes on past the age 18 cutoff. Second, the parent-child relationship is special, so while you may still have close relationships with other people in your life, when we're talking about substantive due process rights, we look to our nation's practices and history and tradition. And there are two reasons why the parent-child relationship is a distinct one from the hypothetical that Your Honor presented. The first is that under this court's precedent, in cases like Stanley or in cases like Santosky v. Kramer, this court was very clear that the interest that a natural father has in having a right to companionship with their child is cognizable and substantial. So under this court's jurisprudence, it defines the parent-child relationship specially. But secondly, when we're looking at our nation's history and tradition and practices, we don't just look to this court's jurisprudence alone. We do a survey of the practices across the nation. And there are 38 states in this country that recognize a right to recovery for a harm against an adult child. This is because most of the states in our country respect and understand that the relationship that a parent has with their child does not magically go away when that child turns 18. So when you look at those factors, it becomes clear that our nation's history and tradition treats the relationship between a parent and a child specially, and it's of particular importance.
Counsel, you also raise an intimate association claim. I understand you to bring in a 14th Amendment claim. Isn't intimate association a First Amendment claim under Roberts?
Yes. In Roberts v. USJCs, the First Amendment, which is captured by the Due Process Clause of the 14th Amendment, would apply to the Baltimore Police Department. And the First Amendment has a right to intimate association. In cases...
But what is the scope of the holding of rule of intimate association that Roberts adopts? Does it even have a holding with respect to that? That's dealing with the JCs.
Yes. Roberts makes two incredibly important pronouncements that are applicable to this specific case. First, Roberts says the core and quintessential relationship that would trigger a right to intimate association is that which pertains to the creation and sustenance of the family. And second, Roberts lays out a series of factors that we look at when we're determining whether a right to intimate association is triggered.
But how is that a holding if Roberts didn't involve a family? What's your best case that actually holds that that right to intimate association applies in the family context?
Yes. So beyond the words of Roberts, which says that this right would apply to family members, you can also look to other cases, City of Dallas v. Stanglin or Boy Scouts of America. There were several cases where the court, this court did not necessarily say that individual family members have this right, but it did outline the factors and type of circumstances when this right triggers. It looks to the size and scope of the relationship, the congeniality of the relationship, the purpose of the relationship. In essence, a lot of these cases are looking to a smaller and more intimate relationship. And we certainly see that present in this case. It's a relationship of two. It is the relationship between a parent and a child is a special one. Anthony Huntington was not just inviting any person to witness the birth of his grandchild. He wasn't inviting just any person to Thanksgiving dinner with his family. He wasn't just welcoming any person into the most intimate aspects of his life. He was welcoming his biological father into his life. So under this court's precedent in cases like Roberts, the factors that are laid out are met. So the First Amendment right to intimate association is a second avenue under which this court can find that there is a right to companionship between a parent and their child.
So you mentioned, counsel, a minute ago, there are 38 states that have already passed legislation, I think is suggested, to cover this type of recovery. Is that right?
Yes.
Well, if that's the case, if 38 of the 50 states, shouldn't we just wait for the other 12 to come around? I mean, why are we making this a constitutional issue when the legislators themselves have established that they recognize this and they can take care of it for us?
There's two responses to that question, Your Honor. The first is that the first would be that Maryland is not one of those states,
Sure.
and that does not give any relief to petitioner and the loss that he experienced from the loss of his child. The second is that there are a great deal of situations and scenarios where a constitutional right and a state tort right or state statutory right can be implicated. But that doesn't change the fact that under the federal Constitution, there is a comprehensive right to companionship. But the third response would be that of these 38 states, not all of them define the right uniformly, as it would be true under a federal constitutional rule. In some states, there may be age caps that are higher than age 18. In others, there may be different standards or showings of dependency required.
Why is that a bad thing?
If I may...
You may answer the question, counsel.
Oh, sorry.
Yeah. It is a bad thing because the clear standard that this court should adopt that best comports with constitutional principles is that there is a right to companionship between a parent and their child, period. And it is for those reasons that this court should reverse the Fourth Circuit Court of Appeals decision. Thank you.
Thank you, counsel. We'll now hear from the other side.
Mr. Chief Justice, and may it please the court, my name is Ahmad Shana, counsel for the respondent, the Baltimore Police Department. I respectfully submit that our Constitution does not recognize a parental right to companionship with an adult child, and I ask that this court affirm the ruling of the Fourth Circuit for three chief reasons. Firstly, because this court's precedence does not support recognizing a parental right to companionship standing alone outside the context of raising minor children. Secondly, any parental liberty interest ends at the age of majority when constitutional protections shift to make way for the autonomy of the young adult child. And thirdly, even assuming that such a right exists, the relationship at issue here, after decades of silence in a single meeting, was not nearly substantial enough to pass any threshold for constitutional protection. Now, as to my first point, that there is no distinct standalone right to companionship outside the context of raising minor children, as the Third Circuit correctly observes in the case of McCurdy versus Dodd, if we look at all of this court's precedents with respect to the parental liberty interest, we find that all of them have dealt exclusively with the right of parents to make critical child-rearing decisions with respect to the care, custody, and control of one's minor children. This parental liberty interest is well-defined and has been revisited by this court many times, going back to Meyer versus Nebraska until the present. And it wasn't until 1972, in the case of Stanley versus Illinois, where this court introduced the word companionship into its description of this right. Now, a reasonable interpretation of this is not that the court was creating a new right that it had never acknowledged before, especially as this court is not typically in the habit of mentioning new rights without some kind of analysis or justification, but rather that it was explicating another side of the parental liberty interest framework that was well established and had only pertained to minor children up until that
Counsel,
point.
in Meyer, Pierce, Moore, did we ever get into how old the children in those cases are? And if we didn't, isn't that a suggestion that we weren't drawing the line you'd like us to draw now?
Correct, Your Honor. In those cases, they never explicitly limited to minor children, but given the nature of substantive due process and this court's repeated reluctance to expand the concept beyond what has very firm legal and historical grounding, given that there is no context where this court has ever explicitly said that the right continues into adulthood, it would be an unwarranted expansion of the concept to recognize it.
If California had a law that said that parents could not help send their kids to private colleges and that they had to go to the UC system, you don't think that would be a clear violation of Pierce just because the kid was over 18?
If the kid is over 18, then I would not say that that is a constitutional violation, because as the Third Circuit also notes in McCurdy versus Dodd, this parental responsibility, this parental liberty interest, is predicated on decision-making, and definitionally there must come a point where the child has a requisite level of maturity to start making those decisions themselves, and that is when...
Isn't that going to be maybe on an individual basis? In other words, wouldn't it be better to define the right based on something like, as I said earlier, the development of the child, the control of the child's education, things that have been traditionally protected, and not worry about the age of the child? Because then if the child's 19 or 20, but there's still an issue with development and education and all of that, then the right is still protected. Wouldn't that be covered by our tradition and history when it comes to the family unit?
Well, Your Honor, in this court's precedent in Roper v. Simmons, this court set out to deliberate whether it was constitutional to execute via capital punishment someone below the age of 18. And in doing so, they found that it was cruel and unusual, but at 18 it became constitutionally permissible because the child, though before that age was considered too immature and underdeveloped to justify that kind of punishment, at 18 it became okay. But in that case, the court noted that it was a messy line and that there were qualities in young adults and juveniles that maybe overlapped. But the court there stressed that there had to be a line. And by and large in our society, we have drawn that line at the age of 18. If we look at virtually every state constitution, including that of Maryland, the age of majority is 18. 18 is the age you can enter into a legally binding contract. It's the age that you can join the military. And according to our 26th Amendment in the Constitution, that's the age that you can vote in the national election. And that's no small thing, because that is essentially the state saying that you have now reached a requisite level of maturity and development to participate.
Right, but you have to be 21 to drink. You have to be 25 to rent a car. I mean, we do have these other lines that are drawn. And so it seems to me that, isn't it more fluid than that? I mean, shouldn't we look to maybe the situation in a particular case? I can think of a situation where if someone's child is developmentally disabled, Down syndrome, quadriplegic, where the parents are still playing a caring role, doesn't that move this case maybe past 18 to a little older than that?
Well, Your Honor, in those situations where someone is disabled or is a paraplegic, as you say, generally those things are addressed by state and statutory laws, and rather than the parental liberty interest. It's true that there are certain things you can't do until 21, in other cases until 25, but given that the parental liberty interest is predicated on this decision-making responsibility, given that children are immature and underdeveloped and unable to make these decisions in an informed and mature manner, it does not stand to reason that we can say that this child is that he has not emerged from the parental liberty interest or continues to be tethered to his parents, when at the same time saying that you are now mature enough to vote, you're now mature enough to enter a legally binding contract, and you're now mature enough, according to Roper v. Simmons, to be executed for a crime, that you can be held accountable to the law with the most severe punishment there is.
But does the Roper analogy break down because that's the opposite of the test we're applying here? Under the Eighth Amendment, we're looking to evolving standards of decency, which is a more presentist and future-oriented test, whereas under the 14th Amendment, we're trying to discern whether there is a deeply rooted history and tradition looking backwards.
Well, Your Honor, I cite Roper merely to illustrate the principle that the decision-making responsibility, which courts have articulated as being central to the parental liberty interest, shifts when a person turns 18 generally in this country. And to comport with that principle, it makes sense that the parental liberty interest should end at that age, because to recognize it further than 18 would be to implicate a young adult's autonomy. If we look at virtually every precedent where this court has discussed the right to companionship, that has been without exception within the context of care, custody, and control of children.
How does it affect the decedent's autonomy here for his father to be able to recover for his killing?
Well, Your Honor, it affects it in two ways. Firstly, constitutionally speaking, while petitioner may assert that a right to a relationship free from government interference does not necessarily implicate autonomy, if we recognize a judicially enforceable liberty interest, there is necessarily going to be a restructuring of that relationship. Now, if a father and a son have maybe a tenuous relationship and the child doesn't want anything to do with them for reasons the state might never understand, now the father may have a claim, especially if the son is involved in some government program, like a public housing program or even prison or the military. And now the father can draw that child into court, even if the son never explicitly consented to that right. And a judge is going to have to sit there and validate and analyze that relationship, even if ultimately the claim doesn't succeed. But there's necessarily going to be implications on the child. In the case at bar, we know that the relationship between Anthony Huntington and Mr. Timothy Gray was tenuous at best. Mr. Gray was not present for the birth of Anthony Huntington and continued to be absent for 23 years until shortly before his death.
But counsel, in Lawrence, Obergefell, Dobbs, we typically don't do our substantive due process analysis at the retail level in terms of trying to understand the specific analysis, right? Obergefell was dealing with an estate matter where one of the spouses had deceased. Windsor, again, one of the spouses had deceased. Lawrence, there's controversy over whether they were actually in a relationship. So the specific facts of a particular petitioner can't defeat the recognition of the right as a general matter at this stage, can it?
No, Your Honor, you're right in that as far as recognizing the fundamental right as existing under the Constitution or not, we're not going to look to the facts of Mr. Gray and Anthony Huntington's relationship specifically, but the proper analysis, as the Fourth Circuit noted when analyzing this very case for whether a fundamental right exists, is that of Washington versus Glucksberg, which requires that a right be objectively deeply rooted in this nation's history and traditions. Furthermore, according to Judge Nelson in his concurrence in the Ninth Circuit case Sinclair versus City of Seattle, when it comes to these substantive due process rights, we only recognize those rights whose contours have been historically clear. If we look to the parental right to companionship, which under Washington versus Glucksberg we are to define carefully, we're talking about a legal right for a parent to have companionship with an adult child that is enforceable against the state. If we look to our history and traditions, we do not find any explicit precursor to this right. There's no founding era statute. There's no statute from the time of the drafting of the 14th Amendment. If we look to the great common law authorities that this court repeatedly consults, from Sir William Blackstone to Chancellor James Kent, we do not find that he writes of these rights anywhere. And of course, within this court's precedents, there is no mention of a distinct right to companionship. And so to say that the right is objectively deeply rooted with contours that have been historically clear is to stretch the concept of substantive due process beyond what has legal and historical grounding.
And how do you account for our approach in Meyer, Pierce, Griswold, Eisenstadt, all of these cases where there wasn't at least a very specifically defined tradition, and yet we recognize that the family was still at the heart of a system of laws, and supporting the family is important, and so we still decided, even in the lack of historic precedents for contraception, for private school, for teaching languages in the home, we still recognize rights to those.
Yes, Your Honor. However, as of 2022, with the case of Dobbs versus Women's Health Organization, the court has indicated that the test going forward for creating new substantive due process rights is that of Washington versus Glucksberg. And while it's true there are cases like Obergefell and Loving versus Virginia, which embrace more of a living constitution approach, those cases involved existing rights that excluded certain classes for certain reasons, and the court was merely expanding the right to encompass these excluded classes. However, here we have a right that has never existed explicitly, and we're seeking to create a new one. And so under Dobbs, and even last year in Department of State versus Munoz, which again used the Glucksberg analysis, that is the proper analysis. And if we want to recognize a new right, we must show that it is objectively deeply rooted and implicit in the concept of ordered liberty.
So explain to me then, counsel, if we go your way in this case, how do we justify the existence of Obergefell?
Well, Your Honor,
from what you just said, are you saying Obergefell is now bad law?
No, Your Honor. In Dobbs versus Women's Health Organization, the court explicitly states that the case is not meant to overrule any of the past fundamental rights cases. It merely implies that going forward, if we were to create any new substantive due process rights, that is the proper analysis. But I'm not proposing that we overrule Obergefell or Loving or any of those cases. Furthermore, even if we are to operate under the assumption that this right exists and that it extends beyond the age of majority to encompass the likes of Anthony Huntington, we find that the relationship at issue here is not nearly substantial enough to warrant constitutional protection. This court has a number of precedents which illustrate the principle that your parental liberty interest is predicated on having an actual, meaningful, sustained relationship with the child. For example, in Larry v. Robertson, this court held that while it's true that a natural father has a unique opportunity to create a relationship with the child that is constitutionally protected, the father has to, quote, grasp that opportunity by coming forward to participate in the rearing of the child and to take some measure of responsibility for that child's future and to demonstrate, quote, a full commitment to the responsibilities of parenthood. Under this standard, we cannot say that a single meeting between Mr. Timothy Gray and Anthony Huntington and vague promises of future involvement, especially after 23 years of absence, should suffice to establish his parental liberty interest in this case. Furthermore, in the case of Quilloin v. Walcott, this court revisited this idea again, finding that the fact that the father had not had a custodial relationship, had not supported the child, and to use the exact language, had not shouldered any significant responsibility with respect to the daily supervision, care, protection, and education of the child, that weighed against recognizing his rights.
Counsel, are most of those claims arising in areas where positive state law is already drawing lines with respect to a father's custody or obligations? We don't have any of that here. This is a freestanding right to say that the state took my child away, and I have a right to that child's companionship.
Yes, Your Honor. And I submit that the proper vehicle to address these kinds of harms is tort law, not substantive due process, as this court has repeatedly affirmed in cases like Paul v. Davis and Collins v. City of Harker Heights. When it comes to the due process clause, to use the language of Paul v. Davis, the 14th Amendment is not meant to be a font of tort law whereby you superimpose the 14th Amendment over systems that are already being administered by the states. In Collins versus City of Harker Heights, it also said that the due process clause of the 14th Amendment is not meant to supplant traditional tort law. We see this sentiment reiterated multiple times, and as the Seventh Circuit noted in the case of Russ v. Watts, if we recognize a parental right to companionship, we risk constitutionalizing all alleged harms against anyone who happens to have a family. And now we have, any time that something happens to anyone, there's potentially, just because they have a father or a mother, there's potentially a constitutional claim on top of the state tort claim, and that would draw the federal courts into analyzing these relationships, and that's not the purpose of the due process clause or the 14th Amendment.
Sure, but I guess the question was making a slightly different point, that if in many of these cases, it's the state who's asserting its interests. It's the state that says, well, that relationship isn't tight enough under our laws, and therefore there shouldn't be an overriding constitutional issue to vindicate that companionship. That's when we have gotten into details, because we've had to assess the state's interests in denying that companionship. This case doesn't present a state law or a state interest. We're just asking whether there's a liberty interest itself in one's child being alive.
Well, Your Honor, I would submit that the state does have an interest in ensuring the autonomy of young adults that are untethered by parental liberty interest. It does. There is a state interest in making sure that if a child wants to come into their own and carry out their lives the way they wish without being connected to their parents, that the state should ensure that as part of their own interest.
But we'd only reach that after we determine there's a right, correct?
Correct, Your Honor. Now, if we look at all the court's precedents with respect to the right to companionship, we find that all the rights that is typically mentioned alongside are care, custody, and control, all of which very clearly pertain to the rearing of minor children. If we are to accept that this serves as evidence for a distinct standalone right to companionship, we have to accept that somehow all of these rights that is always mentioned alongside are different in that they pertain to minor children, and this companionship right somehow is alone in transcending the age of majority to encompass adult children as well. As the Third Circuit and the D.C. Circuit noted in the cases of McCurdy versus Dodd and Butera versus D.C. respectively, this court never indicated any intent to depart from the parental liberty interest framework or to extend companionship beyond the age of majority. Accordingly, in light of the foregoing reasons, because the Constitution does not recognize a parental liberty interest beyond the age of majority, and because any such interest must end to make way for the autonomy of the young adult, and because the minimal and belated relationship between Mr. Timothy Gray and Anthony Huntington was not nearly substantial enough to warrant constitutional protection, I ask that the court affirm the ruling of the Fourth Circuit, consistent with its longstanding commitment to judicial restraint and its refusal to create new substantive due process rights absent clear historical and legal precedent. If the court doesn't have any further questions, I cede the rest of my time.
All right, thank you, counsel. Rebuttal.
Thank you.
The right to companionship between a parent and child is not just some manufactured right that supplants tort remedies, as respondent would have us believe. It is a right that is deeply rooted in our nation's history and tradition and is essential to concepts of ordered liberty. The relationship between a parent and a child strikes at the heart of intimate human relationships. This court has repeatedly ruled that the interests of a natural father are cognizable and substantial. And when you look to the survey of tort practices across this state, it's not so much that these tort practices exist. It shows that this is something that is widely respected across the nation as an important right.
So it's an important right, but it's not a right that the respondent, or excuse me, the petitioner exercised in this case at all, is it? There was no, you would acknowledge there was no father-son relationship here, correct?
There was not.
There was a meeting, right?
Yes. Two responses to that question, Your Honor. This gets to the Lair, Colloy, and Michael H. line of cases that respondent referenced. And there are a couple of key distinguishing factors from these cases to the present situation. The first is that these do not stand for the proposition that a right doesn't exist. It stands for the proposition that the right can be waived or forfeited by certain conduct or lack of care. So in the situation that we saw in Colloy or in Lair, prior to the initiations of legal proceedings, there wasn't indications that the parents were trying to be involved in their child's life. While we see here, before any legal process whatsoever, Timothy Gray tried to rekindle his relationship with his son, and that relationship was reciprocated.
Well, I think it was the son who tried to rekindle the relationship with the father, correct? It was the son who reached out to the father, and the father showed up at a meeting. And they hugged at the end, and that's pretty much all you have. You have an anticipated future relationship, but there's no actual relationship here. So is this really the right case for us to be deciding the contours of this companionship right?
This case is certainly sufficient for deciding that there's a comprehensive right to companionship, and that alone is enough to reverse and remand the lower court's decision, which said there is no right to companionship. Whether there is, in the particular facts that we have here, sufficient circumstances, we would still argue that there are. In order for a right to be forfeited by not being there for your child throughout their life, you still have to have a right to forfeit. But we would argue that there's distinguishing factors. So in cases like Lair or in Michael H., those parents were unwed or they were children that were born out of wedlock. There were intervening interests of the child because the fathers were trying to intervene in adoption proceedings. So those cases do not really get to the heart of what the court would decide in this case here. And that is simply whether the right to companionship is comprehensive between a parent and a child, or should it arbitrarily cut off at age 18? And this court's precedent said there should not. This court's precedent clearly stands for the proposition that there shouldn't be arbitrary cutoffs. In Moore v. City of East Cleveland, this court said that we do not draw arbitrary lines when deciding substantive due process questions. We look to our nation's history and tradition and practices. When we look at cases like Obergefell, it implores us to define rights comprehensively and to decide whether there is sufficient justification for excluding adult children from this right.
But Glucksberg tells us to define rights specifically, right? And I think I still don't know what your definition is of the right to companionship. I heard a few examples, but I'm not sure I know do you have a definition of it?
Sure. So to the extent that Glucksberg sets up a different test, Obergefell directly refutes it by saying that when you're talking about the right to die, which is a more independent right that didn't really exist, you need to have some type of grounding historical examples. So that's what Glucksberg means by defining the right carefully. Obergefell directly refutes this by discussing how this court has never looked to historical examples of interracial marriage rights. If I may continue responding to this.
You may finish your point.
Thank you. Obergefell makes it clear that we do not have to look for one-to-one historical examples because otherwise people who were denied this right could never exercise it going forward. And to the extent that Dobbs would purport to overrule Obergefell, even that case stands for the proposition that arbitrary lines in substantive due process principles are a problem. So what the court should do here is simple. Rule that there is a right to companionship, an already existing right to minor children. It shouldn't be limited to minor children. And it is for those reasons that this court should reverse the Fourth Circuit Court of Appeals and remand the decision. Thank you.
All right, thank you. With quick applause, if we could. So now that they've done their job, we have to do our job and deliberate, which is not going to be easy. So this matter is submitted. We're going to walk back there, deliberate. I think you have some speakers in the meantime. We'll be back in about 20 minutes to deliver the verdict. All right.
All rise.
Watch your head down. You have to be quiet. It's all right. You may now be seated. All right. Okay, I'd like to say while the judges take some time to deliberate, I want to use this time to reiterate our thanks for everyone who made this competition possible. First, I want to say thank you and congratulations to all the competitors who participated in this year's competition. Writing a Supreme Court level brief and performing in oral arguments is no easy task, especially considering the busyness of law school. This year's competition was very competitive, and every cutoff from the best brief scores to the oral argument scores, they were incredibly close. All of your hard work shown in your performances this year, and the board is proud of you all. I'd like to say thanks to all our volunteers, the professors,
practitioners, and judges who dedicated so much time to our competition. And thank you to the 1L bailiffs as well, who kept time throughout those rounds, and our reliable 1L fellows, Alex Davis and Thompson Sue, who assisted us throughout the competition. I'd like to thank our event coordinator, Leslie Dodds, for her assistance in organizing the quarterfinal, semifinal, and final oral argument rounds, and to our faculty support, Naomi Aguilar, for her help in ensuring that the preliminary rounds and the top 16 rounds went smoothly. I'd like to thank Professor Paul Hoffman for providing brief writing training for all our competitors, and to our Dean, Dean Parrish, thank you for your support of the program. And of course, to all the Moot Court board, I'm so happy that we were able to do this together, and from the bottom of my heart, thank you for making this happen. Running this competition takes a tremendous amount of dedication and time, and the competition could not have existed without you all. Now, before I welcome our faculty advisor, Professor Beatrice Tice, to announce the winners of the Best Brief, Best Oralist, and the runners-up to those awards, on behalf of the board, Professor Tice, I want to thank you for your commitment and enthusiasm throughout this competition. You kept us steady when things got difficult and showed us a type of unwavering support that student organizations can only hope for. For that and more, we thank you. Now, without further ado, please join me in welcoming faculty advisor, Professor Beatrice Tice, who will announce the winners of the Best Brief and Best Oralist awards with their runners-up. Thank you.
Good afternoon, everybody. How lovely to see you here. Wasn't that an awesome pair of performances? I still have goosebumps. Yeah, really fabulous. And admitted students, as the Chief Justice said, this could be you. Seriously, in 2 years. Yes, exciting times ahead. All right. Well, my job at the podium this afternoon is twofold. And in a bit, as Matthew alluded to, I'm going to be handing out some great awards. But first of all, it's my turn to thank the board. And in so doing, I'm going to give you all a little peek behind the scenes of what it takes to put on a moot court competition. All right. So, from high-level constitutional discussions down to the nitty-gritty details of, all right, so who's picking up the food for the judges on Monday evening? This incredibly dedicated, talented, professional, and collaborative group of almost lawyers shone at every single moment. To begin with, a moot court competition isn't a moot court competition without a problem for the students to argue. This board, just under a year ago, chose a wonderful from-scratch problem that came directly from a split in the circuits. And that meant that they had to produce everything from scratch. Well, as soon as that problem was chosen, bench brief directors extraordinaire, J.P. Elberfeld, ably supported by Sunny Liu, went to work. They researched the problem exhaustively and teased out all the issues. They then sat down and created the story behind this problem and the statement of facts. They then drafted 2 lower court opinions, trial exhibits, court orders, and they ended up by pulling it all together into a masterful 60-plus page bench brief that the judges throughout the competition and today used to formulate their questions. It was a magnificent endeavor. All right, so we had that. The students then wrote their briefs, and they submitted them. And that's what they did during the first semester of this year. Well, then we needed someone to mark the briefs, to score them. And that is where our internal relations directors, Matthew Finn and Kazra Mirtabegifini, stepped in. They recruited a wonderful group of volunteer brief scorers from amongst our faculty and staff, and then gently urged us, prodded us, and encouraged us to get it all done and get it in on time. Wrangling a bunch of law professors is like a lot worse than trying to herd cats. So sorry, guys, but great, great job. All right. Then the oral argument portion of our competition came to be. And for that, we needed panels of 3 judges to preside over arguments, over 60-plus arguments where our students competed. And so to the rescue came the judicial relations directors, and that's Devin Ton and Karen Trin. They worked tirelessly to recruit a small army of volunteer judges from our wonderful legal community around here in California. And then, having recruited them, they coordinated their appearances. When were they coming? Where should they park? Do they have any dietary restrictions? And yes, who's going to pick up the food? And so under their aegis, everything ran so smoothly. So great job with that. Finally, this whole process needs some people to oversee it from a high level, to make sure that everything is on track, to make sure that everything is progressing smoothly. And no group of individuals could have done this better than the executive committee of the Moot Court Board. That consists of Katie McKee, vice chair, of Jay Naramatsu, vice chair, and our awesome chairman, Matthew Scammahorn. We could not have done it without all of you. You have produced an extraordinary Moot Court competition this year, the culmination of which we all really enjoyed today. So, on behalf of the law school, on behalf of everyone connected with the Moot Court competition, and most especially on behalf of myself, thank you from the bottom of my heart. Friends, the 2024-25 Moot Court Board. All right, and now, I'm not going to cry. I am going to give out a few wonderful awards. Before I do that, though, I would like to say a few words to every student who took part in the Moot Court competition. There's one thing that the board and I really hated doing, and that was a terrible word, eliminating people. Because to all of us, every one of you who took part in the competition is a clear winner. And I don't have a tangible award to give you, but you're all winners anyway, and you know it. You won in that you committed your time to this extracurricularly, so in addition to everything else you were doing. You honed your legal research, writing, analysis skills, your time management skills, your collaboration skills as you wrote your briefs with your partner. And then for oral argument, you got over those nervous jitters, you stood up at that podium, and you performed on the lawyer's stage. You gave a big step forward in presenting your presentation skills, but also in defining your own professional identity. One more step to feeling how you are going to be a lawyer and what that is going to be like for you, how you're going to make it. So to every single person who participated, I just say congratulations to all our students. Let's give them a round of applause. All right. Now I do have two tangible awards, or two categories of awards to give out. And they are Best Brief and Best Oralist. The Best Brief Award, of course, recognizes the teams of students who scored the highest in our competition. And for the runner-up for Best Brief, I'd like to welcome to the stage Shannon Chung and Danny Jaffe. This is yours. Thank you. This is yours.
Thank you.
Thank you. We're going to take photos there. Sure.
Sure.
Okay, yeah, here, get over here.
We go over here?
This side.
Or, I don't know where you want me.
A little more. Great. All right. And the winners of our Best Brief Award, I'd like to welcome to the stage Mika Foster and Connor Leonard. I have your plates here. I hope I am not putting fingerprints on them. All right. Mika, for you. Connor. For you. All right. All right. Great. Thank you so much. And now for our Best Oralist Awards. The Best Oralist Award recognizes the student who, after the general part of our Moot Court competition, finished with the top scores. For the runner-up Best Oralist, can I welcome Miles Maxey? You took the long road. Here you go. All right. Thank you. And the winner of our Best Oralist Award for 2024-25, Connor Leonard. Here's the companion. Thanks. Oops. Thanks. Great. Thank you. All right, well, that ends my podium duties for the day. The judges are, as they say, deliberating, hard at work. I don't know how they're going to make a decision myself, but we'll see what they do, and I'm sure they'll be back soon. At that time, we'll call the court to order and hear what they have to say, but for now, you are free to talk amongst yourselves, all right? Thank you again for coming today.
I used to box, so I'm kind of used to doing this. Please grab a seat. So here's the procedure. We're going to give feedback first, then we announce the winner. Okay, so you two just gotta hang in there, all right? So whenever I'm asked to do a moot court, I live in San Diego, so not that far. It is on a Friday. That's not great. So you're really hoping, like, this better be good. I'm just being honest. This better be good. I got other stuff I could be doing right now. I have this job where I actually get paid to do this part. So you're really hoping that the people are good. And you guys were really good. I encourage you to watch arguments of our court, the Ninth Circuit. They're on YouTube, every single one. And let me tell you, many of them are very bad. I know the new incoming students are like, wow, every argument is like this. No, they are not. People pay a lot of money to lawyers to give really bad arguments. Student arguments tend to be very good, and this was one of those. So I want to take just a minute to say why, but then I want to turn it over to my colleagues. Both of you did an outstanding job of listening to the question and answering that question. I cannot tell you, it sounds simple, right? It's not what you're supposed to be doing. It often doesn't happen. And that is so important for you to listen to the question, answer the question, and then explain why either it ultimately doesn't matter or why it's even more in your favor. The key to oral arguments, in my opinion, is that ability, and also the vibe you want to give, which both of you gave, was, hey, this is a really hard question. I'm just here to help the three of you. I'm just here to help. I'm a smart, nice person, and I'm prepared, and I just want to help you. You're not talking to us, you're helping us with a very difficult question. And both of you, by answering our questions directly, gave that vibe. And I cannot stress for future lawyers out there, that is the vibe you want to get. If a judge feels they're being yelled at, that is not the way to go. I've seen lawyers lose cases because of that reason. Both of you had the right vibe, which is remarkable. Are you 2 L's or 3 L's? Wow, that's remarkable. That's what you want to convey, and both of you did a great job doing that. And with that, I turn to our board member here for the law school, right?
Yes. I think I was supposed to attend a meeting or something recently. So there are 2 L's because you could never get a 3L in, April of their last year to do the kind of work that was necessary to do what they did here. I'm not up enough on pop culture to pick the right person, but just picture, some dancer, some performer, something like that, and they get on stage and they make it look easy, and everyone's going, I could do that. No, there is so much preparation that goes into that, and so what we all know, is how much work it took you to stand up there and do what you did for the 20 minutes that you each did it. Hundreds of hours, you can tell me, but it was a lot because you knew the case law. You weren't flummoxed by any of the questions we asked. There wasn't anything where I felt like, we stumped them, something along those lines, which easily can happen and usually does in our daily jobs. So my job's a little different from theirs, but it's similar. So I just think that you did a fantastic job of showcasing all of the preparation that you did to get where you were, and excellent.
I'll echo all of that, and I guess it sets me up well to be have the constructive criticism. Because we can always do better. I mean, first of all, I just starting with our petitioners' counsel. Our questions. This is a very hard case. The doctrine's difficult. There's a lot going on. The way you were able to break down. Sometimes we ask compound questions, even though we don't let lawyers do that. So the way you're able to break it down and spell things out repeatedly, you came back to that. It was very helpful in terms of that. And as both of you did, real strong grasp on the cases. There are a lot of cases from a long time to sort out here. A great kind of quick summary. Both times you needed to sit down, which was great at the end. Trying to some of the places when you kind of got backed up in terms of you were able to give us the procedural out, which is always good. It's like, no, you don't need to get to those underlying questions. Just trying to establish a right here. It's really important to refocus us when we're starting to worry about consequences and all those things. You set us back on track there. So I thought those were all good. The one thing that I thought about is this is a case about careful definition. And kind of the first and the last question you got during your argument was, how do you define this? And it was something to deal with companionship and stuff, but it's one of those areas where we want to come away from that with just a catchphrase, because we're going to be living with whatever that catchphrase is in our law for as long as we're on the court trying to decide cases. And so making sure that's as crisp as possible, that's really the only thing that I had to suggest there. For the respondent, again, really well-structured argument. You sat down early. Oh, judges love when you sit down early. It was only a few seconds. You gave the people their money's worth, but you sat down just a little early, and that is great. You grounded it. You were able to come back to some of the arguments you were talking about. So I thought that was all really helpful. There was and my one critique for you, just to be even-handed, is there's always Chief Justice Roberts would always talk about how he'd have his arguments set up as issues and he'd put them on note cards and shuffle them and be able to take them in any order. And there's a time where we lined out your 3 issues. You and I ended up getting to the 3rd issue a little early, talking at the back end of your 1st issue, and we explored that a little bit. You came back around and completed that 3rd issue later on, but it might have been easier to take that 3rd issue right after that 1st issue. But again, these are real quibbles with expert. I sat in court for oral arguments all week. I had some great students up there appearing in front of it, but your arguments were easily among the best, so thank you.
So let's give one more round of applause. And I believe this is the time. All right, so before I say it, sorry guys, just hang in there. This is the longest I've ever deliberated about a winner of a moot court ever. I've done this more than once. In fact, JP, where's JP? There he is. He actually knocked on the door and we said, JP, get out of here, we're not done. So I want to say this was extremely close. And, one of the things you have to do in this job, if you ever become a judge, she has a harder job than we do because she has to sentence people. That's really hard. But there's a winner and there's a loser. And that's just the nature of this job. You have to be willing to say that. And so it's not always fun to do that, but we do have to do that. And so after this very, very long discussion, we decided that the winner is Ahmad.
runner-up, come on up.
Yeah, Danny. Great job, Danny.
Yeah.
Killing it.
Congratulations. Can we have another round of applause for both the participants? Maybe one more thank you. It's our final bench here is extraordinary. They have a lot of other things they could be doing than spending time with us. There's a lot of things in the news right now where you see attacks on judges. I have to say, I can't be more proud to be in the Ninth Circuit and the Central District of California, where the judges have just such integrity and are amazing, dedicated professionals. And that's certainly true for the 3 judges we have here, who not only care about the judging, but also giving back to the next profession. It is absolutely amazing, the judges we've had that have come to the schools to support our students, and we really appreciate everything you've done today. Can we have a round of applause for our final judges? Well, that was phenomenal. I now have the great fortune to say that this concludes our Moot Court Finals. We're going to stay here and take some photographs with the finalists and the Moot Court Board. I hope you'll join us out in the auditorium for the refreshments. I see Leslie looking at me. Am I directing in the right direction? Yes, I am. So I'm doing this right. So if you could join us in the lobby for refreshments, and finalists, brief writers, Moot Court Board, judges, and sponsors, if you can stay for photos. Thank you so much for joining us in the 2025 Moot Court Finals.